Many times the landlord and the tenant show up, and the tenant just throws their hands up and says, "Well, I couldn't pay my rent. I meant to. They always mean to, right? I meant to pay my rent, and or this thing came up, and I just need a little more time. I plan to pay my rent." Um, but sometimes you'll get a tenant who is absolutely defiant and says something like, "I'll pay my rent when they fix the toilet, or fix the window, or reshingle the roof, or yada, 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 yada." And so most judges will shoot down these issues about repairs. Some of the better courts will address the issue of repair in their opening kind of statement to the participants at trial. So some judges will come out and they'll give a little speech about what everybody in the gallery can expect in terms of the eviction docket. Some are very straightforward about the issue of repair, and they'll say issues of repair just don't come up. I don't entertain them. The property code doesn't allow them. But not every judge is that way, and some judges very much will entertain questions about repair and will hold it against the landlord when repairs are not done. And so, what do you do if you get sideswiped at trial with a tenant that is demanding repair? Well, so one good defense to that is your lease. And so the lease should explain the process and the procedure for making repair requests. And so if you're at trial and you haven't brought your case file, you haven't brought every document that's related to this tenancy from the beginning, you've already made a mistake. Make sure that when you show up to trial, you bring all of the repair requests, because you might get asked about them. And if you look in your file and say, "Your Honor, there are zero," and it's because you brought the whole thing, you brought everything that pertains to this case, and not once did the tenant make a written request for repairs. If your lease requires that, you've got a good defense to their attack on your claim for rent. Now, the truth is, it's not even one that you should be forced to bring up, but you should be prepared to do it. Because again, although the law says a certain very limited scope of issues are handled in eviction, you have to be prepared for that tenant who comes up and talks about the leaky roof, or the hole in the wall, or whatever, the door that's fallen off its hinges, because it will come up. And so because some judges are more swayed than others to reconsider an eviction, it's important to be able to take a record of whatever was presented. And if there is a record of written requests, you should have a follow-up behind that. You should be prepared to say, "And this is what we did in response," right? Because nothing's worse than having a folder full of repair requests that you're going to get around to eventually, or that you plan to take care of once you get this guy out. A court might look at that and say, "Look, I'm not going to make a ruling here until you do something." Now, the right thing to do would be for the tenant to file a repair and remedy lawsuit against you. But whatever the judge says, that's the law. That's his or her order in this case. And if you give your tenant a foothold because you haven't done repairs, well, that could be a problem. Now, generally speaking, a tenant's failure to pay rent usually stops your obligation to make repairs. But that's going to depend on a case-by-case basis. Something egregious, like a giant hole in the ceiling, you're going to have to deal with. Something more cosmetic, not so much. And so if you've been diligent on any repair requests, you should be fine. But if the tenant brings up some stuff from 18 months ago or whenever, but there's no reflection of it in the case file, and whatever it was that they may bring up, you actually addressed, all that's going to help you. So be prepared, even though issues of repair should not come up. They shouldn't come up in an eviction matter. Be prepared to address them. Have your case file ready. Have proof that you have completed any repair that was properly requested, even the ones that were improperly requested. And if it comes down to a matter of a cosmetic repair, be prepared to discuss it with the court. If they're not paying rent, you don't have an obligation to pay. I'm sorry, you don't have an obligation to repair, but be prepared to discuss what issues have been properly raised and what you've addressed in this case. Again, generally speaking, failure to make a repair is not a valid defense to a tenant's failure to pay rent, but you need to be prepared to talk about repairs. All right. So send me your questions. If you've got questions about landlord-tenant law and there's something you're a little shaky on or something you just need a little clarification, post something in our Facebook group. Shoot me an email at ernie.garcia@attorneyeg.com. It's right there. Or post something in our Facebook group. If you're not a member yet, join our Facebook group. We look forward to you. If you look on Facebook, we are Texas Landlords. Finally, if you want to call, that's our number. Feel free to call us, and we'll be happy to help in any way that we can. And so keep your questions coming. I'm happy to answer as many questions as I can.